someone can clone your voice right now. They can put it in a song, in an ad, on a podcast, and in most of the United States, there's nothing you can legally do about it. If you're an artist, a content creator, or an athlete with a public profile, this video is for you. Because AI voice cloning and the law around it is one of the most urgent intellectual property issues of 2026, and most people don't know where they stand. I'm breaking down what the No Fakes Act is, what states actually protect right now, and what the legal landscape looks like for artists trying to navigate this. A quick note, everything I share on this channel is legal information and commentary, not legal advice. If you need guidance specific to your situation, please consult a licensed attorney in your jurisdiction. With that being said, I'm Stevie, this is Girl Code of Law. Let's get into it. Voice cloning uses AI to generate an audio replica of your voice from existing recordings, your songs, your interviews, your social media videos. It doesn't need your permission, it just needs your audio. We've already seen this play out at scale. Fake Drake tracks flooded streaming platforms. AI versions of deceased artists, Tupac, Amy Winehouse, have appeared in content without estate consent. Voice actors have discovered their voices being sold as AI products they never agreed to. There was a landmark case in New York, Lehrman and Sage versus Lovo, Inc. Two professional voice actors discovered that an AI voice company had trained its model on their recordings from Fiverr, and the company was selling their cloned voices to subscribers. The actors had no idea. Their voices were generating revenue for someone else. And here's what makes this legally complicated. A voice is an abstract quality. It's not protected by copyright directly. Copyright protects the original sound recording, the fixed expression, but not the characteristics of the voice itself. Your pitch, timbre, cadence, breathiness, those are not, at least currently, copyrightable. Which means the legal fight has to happen somewhere else entirely. Which means if copyright doesn't fully protect your voice, what does? The primary tool is the right of publicity, your right to control the commercial use of your name, image, and likeness, and in many states, your voice. And here is the critical thing to understand. There is no federal right of publicity. There are, however, state laws that protect the right of publicity, which means your protection depends entirely on where you live. California has one of the strongest versions. New York expanded its law specifically to cover synthetic media and digital replicas. Tennessee passed the ELVIS Act in 2024, the first law specifically targeting AI voice cloning, and extended those protections to estates after death. But if you're not in one of those states, your protection is genuinely thin. That is exactly what the No Fakes Act is designed to fix. It would create a uniform national standard governing when and how a person's voice or visual likeness can be replicated using AI, regardless of which state you live in. It does have bipartisan support in both the House and Senate, but it hasn't passed yet. It does, however, represent the most significant potential shift in creator and athlete protections in the AI era. There's also the Take It Down Act, which passed federally in 2025. It specifically targets non-consensual intimate deep fakes, which is important, but it's narrow. It does not cover commercial voice cloning for music or advertising. The gap remains wide open. If you're a musician, your recorded vocals, your released catalog, every interview that you've ever done, all of that is potential training data. The major labels have been fighting this through lawsuits and licensing deals. Warner settled with Suno, UMG settled with Udio, but both UMG and Sony are still in active litigation against Suno. A fair use ruling is expected in summer 2026, and it could set major precedent for whether using copyrighted music to train an AI is even legal. Independent artists have far less protection and far less leverage in that fight than those represented by major labels. If you're a content creator, your voice might be a big part of your brand. Every video you post is audio that could be scraped. The Scarlett Johansson situation showed that even a high-profile, documented refusal did not stop a company from getting very close to replicating someone's voice. The legal line between sounds like and is genuinely murky right now. If you're an athlete, this intersects directly with your NIL rights. Your voice is part of your name, image, and likeness. An AI clone of you endorsing a product without consent is both a publicity rights issue and an NIL issue. So what does the landscape actually look like for artists and creators who are trying to navigate this right now? On the registration side, the U.S. Copyright Office is the existing infrastructure most artists are working with to document their original recordings as intellectual property. The Copyright Office itself has been vocal about the inadequacy of existing protections and has actively recommended that Congress create a federal law specifically addressing digital replicas, which is part of what's driving the No Fakes Act forward. On the platform side, the major streaming services have begun responding. Spotify adopted the DDEX standard for AI disclosure in 2025. Apple Music launched transparency tags in early 2026. YouTube has made deep fake detection tools available specifically for artists and public figures. These are platform-level responses to the legal gap. They exist because the law hasn't fully caught up with the technology yet. On the contract side, the conversation right now is heavily focused on what AI provisions belong in every agreement. Who controls AI-generated content that uses your voice? Can your recordings be used to train models? What happens to your catalog after a contract ends? These questions are being actively negotiated across the industry, which tells you they weren't adequately addressed in agreements up to this point. The artists and creators who are best positioned right now are the ones who understand what tools already exist, where the gaps are, and what the No Fakes Act would change if it passed, because the landscape is shifting fast, and the gap between where the law is and where the technology is exactly where exploitation happens. Your voice is an asset. It generates economic value. And right now, the law is only partially keeping up with the technology that's threatening it. If this was useful, share it with every artist, creator, and athlete you know, because most of them have no idea how exposed they are. And subscribe, because next week we're getting into NIL and AI, and it gets even wilder. I'm Stevie. This is Girl Code of Law. I'll see you next time.